Ever feel like you just need a reset button? You know, especially when things get a little tricky.
Yeah.
Well, you might be surprised to learn that in California's legal system, plaintiffs actually have a surprising amount of control when it comes to dismissing their own lawsuits.
Interesting.
So today, we're going to do a deep dive into this whole strategic world of voluntary dismissals.
Correct.
We'll uncover when they can do it, why they might choose to do it, and of course, all those catches you should be watching out for.
That's great. I'm excited to get into this.
Awesome. So think of it as like your shortcut to understanding how dismissals work in California.
Perfect.
Now, one concept that really jumped out at me was this idea of a plaintiff's absolute right to dismiss before trial.
Right.
So what is that all about?
Well, it's kind of what it sounds like.
Okay.
It's a pretty significant, right?
Okay.
And it comes from the California Code of Civil Procedure, Section 581B.
Gotcha.
And it basically says that you, as the plaintiff, can dismiss your lawsuit anytime before the trial actually starts.
Okay.
And here's the interesting part.
Yeah.
This applies to dismissals both with and without prejudice.
Wait, with and without prejudice?
Yes.
That's a big...
There's a difference in how the case actually ends.
Yes, definitely. So if a case is dismissed with prejudice, it means it's over. Done.
Okay.
Can't refile.
Right.
But if it's dismissed without prejudice, that means that you can actually come back and file the case again.
So strategically, then you could use this to avoid like a really bad outcome.
Exactly.
And still kind of keep your options open.
Yeah, you got it.
Okay.
You can think of it as like, you know, you get some new evidence that comes up. And it weakens your case.
Or maybe you realize you'd be better off in a different court.
Okay.
Voluntary dismissal lets you hit the pause button, reassess, and then come back stronger, potentially.
That makes sense.
Yeah.
So are there any situations where you can't just dismiss your case?
Yes, absolutely.
Even if it's before the trial starts?
There are some exceptions.
Okay.
For instance, let's say the defendant files what's called a compulsory cross-complaint.
Okay.
This means that they're not just defending against your lawsuit.
Right.
They're also making their own claim against you.
Yeah.
That's related to your original lawsuit.
Okay.
In that case, your right to dismiss becomes limited.
Okay.
Because now the defendant has skin in the game, too.
So if their claim is directly tied to my original lawsuit, they basically become a plaintiff in a way as well?
In a sense, yes.
And that kind of limits my ability to just walk away?
Correct.
Interesting. Yeah. Okay.
So another interesting one is when a third party gets involved.
Okay.
Someone who wasn't originally a part of your case.
Right.
And they basically say, hold on, I have an interest in this too. They file a complaint in intervention.
Okay.
Saying they have a legal interest in the outcome.
Right.
And once the court allows that intervention, then you, as the plaintiff, can't just dismiss the case without considering their interests.
So the more players involved, the more complex this whole dismissal process gets.
Exactly.
Okay. So what about situations where it's not about the other parties, but it's something about the case itself that might limit my ability to dismiss?
Oh, for sure.
Okay.
So, for example, let's say the defendant is trying to change the venue.
Okay.
They want to move the case to a different court.
Right.
You can't just use a voluntary dismissal to try to block that.
Gotcha.
This is to prevent plaintiffs from using dismissals as a tactic to manipulate the system or avoid potential sanctions.
So no venue hopping to get a more favorable court.
Right, exactly.
Okay, fair enough. What about class action lawsuits?
Oh, that's a good question.
Does the absolute right apply there?
So class actions are a little bit different.
Okay.
Because you have a whole group of plaintiffs involved.
Right.
So the court has to think about what's fair for everyone.
Makes sense.
Not just the person who initially filed the lawsuit.
Right.
So they might require you to notify all the class members before they'll allow a dismissal.
Okay.
Or they might only allow it if they're convinced it won't actually harm the class as a whole.
It's about protecting the entire group.
Exactly.
So we've talked about when this right to dismiss might not apply.
Right.
But let's go back to when it does apply.
Yeah.
You mentioned this right only exists up to a certain point.
Yeah.
What is it that actually ends a plaintiff's ability to just dismiss a case?
The key here is what's called the commencement of trial.
Okay.
Once the trial begins, that's when things change.
Okay, so
the absolute part of your right to dismiss kind of goes away.
So when does a trial actually begin?
Right.
Is it just jury selection?
It's a little more nuanced than that.
Okay.
California Code of Civil Procedure 581B defines trial a little more broadly.
Okay.
It can include certain pretrial proceedings that could effectively decide the case, even if it's not the actual trial itself.
So like a trial before the trial.
Yeah, you could think of it that way.
Okay.
So for example, let's say you have a situation where the case is being heard by a referee.
All right.
Now, the referee's findings might only be advisory, meaning the court can still make the final decision.
Gotcha.
But even then, those proceedings before the referee could be considered a trial under California law.
Oh, wow.
The case Gravy Superior Court from 1997 kind of confirmed that.
So even if it's not the ultimate decision maker,
right,
if that pretrial proceeding starts like digging into evidence and issuing rulings, that could potentially mean the end of my right to dismiss.
Yes.
Okay, that's something to keep in mind.
Definitely.
What about cases that start in small claims court? If they're appealed to a higher court, does that affect things?
Yes, it does.
Okay.
So appealing a small claims judgment to a superior court is considered what's called a trial de novo.
Okay.
Which basically means it's a brand new trial.
All right.
And the courts have been very clear
Okay.
that initial small claims hearing actually counts as a trial in this context.
Okay.
The Acuna v. Gunderson Chevrolet case from 1993 made that clear.
Gotcha.
So once you've had your day in court, even in small claims court, that voluntary dismissal option might be gone.
It seems like once you step into a courtroom, regardless of what level it is, that absolute right to dismiss can disappear.
It can, yes.
What about rulings that happen before a trial? Like a demurrer or a motion for summary judgment.
Yeah.
Do those impact that, right?
That's where things get a little bit tricky.
Okay.
So, for example, if a court decides that your complaint has some, like, fatal flaws and they can't be fixed, then that's pretty much the end of your case.
So in that instance, the case is over and there is no trial.
Exactly.
Right.
And the same goes for summary judgment.
Okay.
If the court grants that motion for summary judgment before the trial, that basically ends the case as well.
Okay.
But there's this kind of interesting wrinkle. The Wells v. Marina City Properties case from 1981 introduced some ambiguity about when exactly your right to dismiss ends.
Oh, ambiguity in legal matters.
Yes, it can happen.
That doesn't sound good.
So the Supreme Court in the Wells case, they just casually mentioned that the right to voluntarily dismiss shouldn't be effected before a decision on a demurrer. But they didn't really go into detail about what they meant by that.
So is there some debate about when exactly the right to dismiss ends? Yeah.
Is it right before the ruling or is it sometime before that?
There's a little bit of a gray area that lawyers have been kind of debating ever since.
Okay, so they love those gray areas.
Exactly.
All right. So what if the trial has already started?
Yeah.
Is there ever a time where you can still dismiss as a plaintiff?
It's not as easy.
Okay.
But it's not impossible.
Okay.
According to the California Code of Civil Procedure, Section 581E, once the trial is underway, any dismissal has to be with prejudice. Unless all the parties agree to a dismissal without prejudice or the court finds good cause.
Okay, so unless everyone agrees or there's like a really, really compelling reason, you're basically stuck.
Pretty much, yeah.
Okay.
There has to be a good reason to allow a dismissal without prejudice.
So what would be considered like a compelling reason?
Well, it's this idea of good cause.
Okay.
And that can cover a lot of different situations.
But basically, it has to be something that would make it unfair to continue the case.
Okay. Can you give me an example?
Sure. Let's say you have a key witness who's caught lying on the stand. Or maybe some critical new evidence comes to light. And it totally changes the understanding of the case. In those situations, the court might be willing to allow a dismissal without prejudice. So that the case can either be reassessed or rebuilt with this new information.
To make sure there's a fair outcome.
Exactly.
Yeah. So exceptional circumstances require flexibility.
That's right.
Okay, so we've really gone through, when a plaintiff can dismiss and when they can't.
Yes.
But what happens after a case is dismissed?
That's a great question.
Voluntarily or involuntarily, what are the consequences?
Yeah, that's a really important question, and that's what we're going to get into next.
Sounds good. We'll continue our deep dive right after this. All right, so we've been talking about all these scenarios of when you, as the plaintiff, can choose to dismiss your case. What happens after a voluntary dismissal?
Well, the first thing that happens is the court actually loses jurisdiction over whatever it is you dismissed.
Okay, so does that mean the whole lawsuit ends?
Not necessarily. It might just be a certain claim or against a particular defendant.
So other parts of the case could keep going.
Yeah, it's really about, it's like hitting a very specific off switch.
Okay, that makes sense.
So there was a case, Viejo Bancorp, if you would.
Okay.
From 1989.
Right.
That kind of illustrates this point.
Okay.
Basically, the court loses its power over the case.
Okay.
After a voluntary dismissal.
Okay.
And it can't even enforce like a settlement agreement unless very specific things happen.
So this is a pretty big deal.
Yeah, it's not just like a temporary pause. It has real consequences.
Right. Okay.
Yeah.
We were talking earlier about dismissals with and without prejudice. Does that change anything about what happens after the dismissal?
Oh, yeah, definitely.
Yeah.
A dismissal with prejudice, whether or not it involves, a settlement or a consideration.
Okay.
It acts like any other judgment on the merits.
Okay.
It prevents the same lawsuit from being refiled. So
you can't just try again.
Right. That's the whole res judicata thing.
Okay. One and done. Yeah. Okay. But what about, a guide mentioned collateral estoppel.
Yeah.
What is that?
So that gets into the specific issues that were actually decided in the dismissed case.
Okay. Okay.
So even if the dismissal was without prejudice, meaning a new lawsuit could technically be filed.
Yeah.
Certain issues might already be settled.
Okay.
Because of this idea of collateral estoppel.
Mm-hmm.
It's like some pieces of the puzzle are already in place.
Gotcha. Okay.
Yeah.
So even if I can file a brand new lawsuit.
Right.
Decisions made in that dismissed case could still come back.
They can, yeah.
And affect other legal battles.
Exactly.
Okay.
Like down the line.
Okay. Can you give me an example?
Sure. So let's say you filed a lawsuit over like a car accident, but then you dismissed it.
Okay.
Later on, you decide to sue somebody else.
Right.
Involved in that same accident for like emotional distress or something.
Okay.
Even though it's a different claim.
Okay.
The court might still use findings from your dismissed case.
Okay.
Like who is at fault in this new lawsuit.
Okay, so legal decisions, even dismissals, can have a ripple effect.
And they can.
Okay, cool.
Yeah.
So we've talked a lot about the plaintiff's perspective.
Right.
What happens from the defendant's side?
Oh, well, they definitely have rights, too.
Okay.
For instance, if the plaintiff had to post a bond as part of the lawsuit.
Okay.
The defendant might be able to sue on that bond after the case is dismissed.
Wait, so the plaintiff might have to put up money just to file the lawsuit?
Yeah, in some cases.
Okay, so when would that happen?
Like, if the plaintiff doesn't live in California, the court might require a bond to make sure that the defendant isn't stuck with costs from a frivolous lawsuit.
Makes sense. Levels the playing field a little bit.
Exactly.
So, are there any other rights that the defendant has after dismissal?
Oh, yeah. Another big one is recovery of court costs.
Okay.
And California law has specific rules for this.
Okay.
Depending on how many plaintiffs or defendants are involved.
So dismissing a case doesn't mean the plaintiff gets off scot-free.
Right, exactly.
All right. That's good for both sides to know.
Yeah.
So, we've gone pretty deep into voluntary dismissals.
We have.
What about when it's not the plaintiff's choice? When the defendant or even the court wants to dismiss a case?
That's where things get a bit more complex.
Okay.
Yeah, because now we're not talking about you choosing to end the lawsuit.
Right.
Now it's either the court or the defendant taking action.
Okay.
These are called involuntary dismissals.
Okay.
And those generally fall into two categories, mandatory and discretionary.
Mandatory dismissals sound pretty serious.
They can be.
So when do those come up?
It really boils down to deadlines.
Okay.
You miss a crucial deadline, and your case could be dismissed automatically.
Okay, give me an example.
So, under the California Code of Civil Procedure, Section 583.210,
okay,
you have 3 years to serve the defendant with the lawsuit.
Okay.
Officially.
Okay.
And if you miss that 3-year mark, that can be grounds for a mandatory dismissal.
3 years seems like a long time, though.
It can be, but, things happen.
Right.
Cases get complicated.
Yeah. Okay.
So
what about that other category? Discretionary dismissals.
So those are a little bit different.
Okay.
Because the court has more leeway in deciding whether a dismissal is appropriate.
Okay. So it's not automatic.
No, they look at a variety of factors.
Okay, so like what would be an example of when a court might use their discretion to dismiss a case?
Well, one common reason is if the plaintiff just isn't moving the case forward.
Okay, like dragging their feet.
Exactly.
Okay.
Maybe they're delaying discovery or not taking steps to get it ready for trial.
Right.
So the court wants to see progress, not stagnation.
It's not just about hitting deadlines. It's also about you're trying to resolve this.
Exactly.
Okay.
And in those discretionary dismissals, the court will often consider whether the defendant has been harmed by the delays.
Right.
So if the defendant can show they've been prejudiced by the plaintiff's inaction, that gives them a stronger argument for dismissal.
It's a legal chess game.
It is.
Both sides need to be aware of the rules.
For sure.
And how their actions or inactions could affect the case.
Exactly.
Okay.
Yeah.
Are there any other reasons a court might dismiss a case?
Oh, absolutely.
Beyond just delays?
Yeah. There are other statutory grounds.
Okay, so what else can get a plaintiff in trouble?
Well, we talked about demurs earlier.
We did.
So if the court finds that your complaint has some, serious problems and you don't take the opportunity to fix them, the court can dismiss the case.
Okay.
And it could even be a dismissal with prejudice.
So if you get a chance to amend, you better take it seriously.
Definitely.
Okay.
So another scenario is failing to pay what are called transfer costs.
Okay.
So let's say the case needs to be moved to a different court.
Okay.
And you, as the plaintiff, are responsible for paying for that transfer.
Right.
If you don't pay up, the court can dismiss your case.
So even like a procedural detail like that can have a big impact.
Oh, yeah, for sure.
Really highlights how important it is to understand the details.
Exactly.
Of the process.
The intricacies.
Okay, are there any other grounds for dismissal that stand out?
Well, one that really kind of underlines the court's authority is failing to comply with court orders.
Okay.
And this could be anything from not producing documents during discovery to failing to post a bond.
Okay, yeah, we were talking about those.
Yeah.
Can you remind me, in what kind of situations would a plaintiff have to post a bond?
So, one common situation is if the plaintiff is not a California resident.
Okay.
The court might require them to post a bond.
Right.
Just to help cover the defendant's costs if the lawsuit turns out to be frivolous.
Right. So it's a way to protect the defendant.
Exactly.
Okay.
Another scenario is in certain malpractice cases.
Okay.
The plaintiff might have to post a bond to basically show that they're serious about their claim.
All right. Makes sense.
Yeah.
So we've covered all these reasons why a court might dismiss a case.
Right.
But how does this all actually work in the courtroom? What are the steps involved in filing a motion to dismiss?
So it's a pretty formal legal process.
Okay.
With specific steps you need to take.
Okay.
So let's say the defendant wants to dismiss the case.
Oh, okay.
Because you, as the plaintiff, didn't serve them the lawsuit on time.
Right.
They would have to file what's called a motion to dismiss.
Oh.
Citing the relevant legal rule, which would be Section 583.210 of the California Code of Civil Procedure.
Okay, so they're pointing to the specific rule they're saying you violated.
Exactly.
Okay, what else?
Well, the motion also has to explain the facts.
Okay.
Demonstrating how the plaintiff didn't actually serve them within that 3-year limit.
Right.
And really important, they have to give you proper notice of the motion, which is usually at least 45 days.
Okay, so even when you're trying to dismiss, there's a process you have to follow.
Yeah, it's a structured process with rules for both sides.
Okay, what about the plaintiff's side? What if a motion to dismiss is filed against them?
Well, they get a chance to fight back, of course.
Okay.
They can file a formal opposition to the motion.
Okay.
Arguing that the dismissal isn't justified.
Right.
They might say they had a good reason for the delay. Or maybe that the defendant wasn't actually harmed by it.
Okay.
So it becomes kind of a legal back and forth.
Right.
With each side presenting their arguments and evidence.
And the judge decides.
Exactly.
Okay.
So
this has been a really, really insightful deep dive.
It has been.
You know, we've explored all these different facets
of
dismissals in California,
right.
From voluntary dismissals by plaintiffs to all these ways a case can be involuntarily dismissed.
Exactly.
And even, all these specific steps and procedures.
Yeah, it's really important to understand all these things.
Absolutely. It's not just about knowing the rules. It's about understanding how your actions or even your inactions can affect the case.
Absolutely.
Okay. But we're not quite done yet.
Okay.
There's still one more crucial aspect of dismissals we need to explore.
Right.
And that's what happens when the plaintiff fails to serve the summons on time.
Right. That's a big one.
Yep.
Very important.
We'll get into all of that right after this. Welcome back. So we've been talking about all these reasons a court might decide to dismiss a case. But there's one situation that's so important it deserves special attention. What happens when you, as the plaintiff, don't serve the defendant with the lawsuit papers on time?
Oh, yeah. This could be a real problem for plaintiffs because California law has these very specific timelines for when you have to serve the defendant with those summons and complaint documents.
Okay, walk me through it. What deadlines are we talking about?
So we talked earlier about California Code of Civil Procedure, Section 583.210, right?
Yeah.
Well, that section says that if you haven't served the defendant within 3 years of filing the lawsuit,
okay,
the court has to dismiss the case.
3 years?
Yeah, it's a hard deadline.
Okay.
And there's an extra part to it.
Sure.
You also have to file proof that you served them within 60 days of that 3-year deadline.
So you have to make sure the court knows you serve them in a certain time.
Yeah, it's not enough to just serve them.
No room for delay here.
Definitely not.
Now, hold on a second. I thought there were some rules about serving and filing proof of service that were a lot sooner than that.
Yeah, there are.
So what's the story there?
So California Rules of Court, Rule 3.11b, says you generally have to serve the complaint and file proof of service within 60 days of when you first filed the lawsuit.
Okay, so that's a much shorter deadline.
Right, but here's the thing. If you miss that 60-day deadline, you might have to pay some money.
Okay.
But you're not going to automatically face dismissal unless the delay is more than 2 years.
Oh, so there's a little bit of wiggle room.
Right. Okay. That's what cases like Hawks v. Hawks from 2006 and Levitz v. the Warlocks from 2007 said.
So you have 2 years, basically, to get things in order.
As long as you're showing the court you're making progress.
Right, not just sitting around.
Exactly.
But after that 2 years, things get serious.
Definitely, those deadlines get a lot stricter.
What happens if the defendant just starts participating in the case before being served?
Yeah, that can change things.
Okay.
So if the defendant takes some action that shows they know about the lawsuit, like they file a response, it's called a general appearance.
Okay.
Then they're basically saying they're waiving their right to object to the delay in service.
So they can kind of reset the clock?
In a way, yes.
Okay.
But there's actually some debate in the courts.
Oh, there's always some debate in the law.
About whether a general appearance during that 60-day grace period for filing proof of service is enough.
To prevent dismissal.
Right.
Okay, so even seemingly simple rules have a lot of nuance to them.
Definitely.
Okay. So are there any situations where those 3-year and 2-year deadlines for serving the defendant don't apply?
Yes, there are a few situations where those deadlines get put on hold.
Okay.
What we call tolled.
Okay, so pause the clock.
Exactly. So the first one is when the defendant just isn't around to be served.
Okay.
Like you can't find them, or they're outside the court's jurisdiction.
They're hiding.
Right, basically.
Okay.
And as long as that's true, the clock stops kicking.
Okay. But you can't just say they're not around.
No, you have to actually prove it to the court.
Gotcha.
You have to convince them you couldn't serve them.
You need evidence.
Yeah, exactly.
Okay, what are some other situations that might pause the clock?
So another one is if something happens that legally stops you from moving forward with the case.
Okay.
Like a stay.
Okay.
But it has to be a stay that directly affects your ability to serve the defendant. So let's say the defendant files for bankruptcy.
Okay.
The case might be put on hold while that gets sorted out.
Right.
And that would stop you from serving them during that time.
So those external factors, legal obstacles, can also affect those deadlines.
Exactly.
And if it's not a legal issue, but it's still really hard to serve the defendant.
That's where the third scenario comes in.
Okay.
Where serving the defendant is impossible, impracticable, or futile.
Okay. Impossible, impracticable, or futile.
Right. It's a pretty broad category.
Okay.
But, you know, how courts interpret it can be all over the place.
Impracticable. I like that.
Yeah.
Can you give me some examples of scenarios that courts have said are okay reasons to delay?
Sure. So let's say your case was mistakenly dismissed and you're trying to get it reinstated.
Okay, so you need some time.
Right. So the court might say, okay, you can have more time to serve the defendant until your case is back on track.
So the delay is understandable.
Right. That happened in Graff v. Gaslight
back
in 1990.
Right.
Another example is You might be waiting for the outcome of a related case, like an appeal, before you serve the defendant in your case. And the court might say that's a reasonable delay. That happened in Diaz v. Knapp in 1982.
So that makes sense.
Right.
It's not really the plaintiff's fault. But I bet the courts aren't always that nice.
No, they're not.
What are some examples where they said impracticable wasn't a good enough excuse?
So one example is where the plaintiff delayed serving the defendant because of personal problems, like a medical condition. And the court said, well, that's not a valid reason to miss the deadline.
Yeah, too bad.
Right? That was Ladd v. Dart Equipment Corp. From 2015. Another one is where a plaintiff waited for something to happen in a totally different lawsuit before serving the defendant in their own case.
Right.
And the court said, nope, not good enough.
Not going to work.
That was American Western Banker v. Price Waterhouse. Back in 1993.
So you need a good legal reason for any delay.
Yes, absolutely.
Not just, personal reasons or trying to be strategic.
Right, the court's not going to buy that.
Okay, good to know.
Yeah.
So we've covered those mandatory dismissals for failing to serve. What about discretionary dismissals for just taking too long to get the case to trial?
So that's where California Code of Civil Procedure Section 583.410 and California Rules of Court 3.1340 come in.
Right.
They give the court the power to dismiss a case. If it's not brought to trial within a reasonable time. Usually within 2 years.
All right, so even if you serve the defendant.
Right.
You can't just relax.
No, you have to keep things moving.
Gotcha.
The court wants to see you actively working towards a trial.
So are there any special rules about how these discretionary dismissals work?
Yeah, there are notice requirements.
Okay.
If it's the defendant who's asking for the dismissal, they have to give you at least 45 days notice.
Okay, so you have time to respond.
Right, but if it's the court who decides to dismiss, they only have to give you 20 days notice.
Oh, wow. That's not a lot of time.
No, it's not.
Okay.
So
that could catch you off guard.
It definitely could.
All right, so what does the court think about when they're deciding whether to dismiss a case for taking too long?
They look at a lot of different things. It's not just about how many days have passed on the calendar.
Right.
They'll consider, how complicated the case is. Whether the parties have been trying to settle. And even if the defendant did anything that contributed to the delay. So it's a pretty thorough review.
They're looking at the whole picture.
Yeah, the entire history of the case.
What about that 5-year rule? You mentioned there's a stricter standard if it takes more than 5 years to get to trial.
Oh, yeah. That's California Code of Civil Procedure Section 583.310. And that was a pretty strict rule. If the case isn't brought to trial within 5 years, it has to be dismissed.
5 years is a long time, but complicated cases can take a while.
It's true.
So when does that clock actually start, and what does brought to trial actually mean?
Yeah, that's a really good question. It depends on how California law defines things. Usually, the clock starts when you file the lawsuit. But brought to trial doesn't necessarily mean the trial has actually started. It could include certain things that happened before trial that move the case forward.
So some wiggle room there.
A little bit. Yeah.
So are there any exceptions to this 5-year rule?
Yes, there are. So one exception is if you and the defendant agree in writing to extend the deadline. That's called a stipulation.
So you can agree to more time.
Yeah, you can. Another exception is if there were times when going to trial was impossible or impracticable.
We were talking about that earlier.
Right, just like with serving the defendant. So
can you give me some concrete examples of things that might pause the clock?
Sure. So one example is if your case was in court-ordered mediation or arbitration within the last 6 months of that 5-year period. Another example is if there was a stay ordered by the court. Like if the defendant filed for bankruptcy. Or if there was a moratorium on trials because of some kind of emergency.
So even if that deadline is coming up, there are still things that can give you more time.
Yeah, but you have to show you were actually trying to get to trial.
Right, not just using it as an excuse to delay.
Exactly. Reasonable diligence is really important.
The court wants to see you're making an effort.
Yes, that's key.
So we've talked about missed deadlines and delays as reasons for dismissal. Are there any other situations where a court might dismiss a case?
Yeah, there are a few other statutory grounds for dismissal.
So what are we talking about?
We already talked about failing to amend a complaint after a demur, right?
You did.
and not paying those transfer costs for a change of venue.
Right, so don't mess up the procedural stuff.
Exactly. Those details can have big consequences.
Yeah. Are there any other situations that could get your case tossed out?
Another one is not following court orders.
Okay.
That's a big one.
Right.
So that could be anything from ignoring a discovery request to not posting a bond when the court told you to.
Yeah, that shows you're not respecting the court's authority.
Exactly. And that can definitely lead to dismissal.
This has been an amazing deep dive.
It has.
You know, we've really explored this whole world of dismissals in California.
We have. There's a lot of information.
From those voluntary dismissals filed by the plaintiff to all these different ways a case can be involuntarily dismissed.
Definitely. Lots of different scenarios.
And all those procedures and deadlines.
Yeah. Knowing all this can really make a difference.
It really can.
To how your case turns out.
Absolutely. It's not just about knowing the rules.
Right.
It's about knowing how your actions and even your inactions
the things you don't do
can affect things.
Exactly. It's all connected.
This has really given me a lot to think about.
Me too.
You know, we've focused on California.
Right.
But it makes me wonder, are these rules fair?
Good question.
Do they protect both the plaintiff and the defendant?
Yeah, it's something to think about.
And what do other states do?
Right. How do they handle dismissals?
That's a great point, you know?
Yeah.
Understanding how other legal systems work can give us a lot of insight.
Definitely.
Well, that's all the time we have for today's deep dive.
Jody?
Thanks for joining us.
Thanks for having me.
It's been a really fascinating journey.
It has been.
Through the world of dismissals in California.
A very complex world.
Until next time, keep on diving.